Hi, the following videos are going to be a great example of critique methodology. What happens in the room when you have critiquers that don't agree? How does the director deal with that issue? And how do each critiquer deal with each other? I hope you find it informative.
Well, good afternoon, members of the jury. I am proud to be here representing the great state of NIDA, representing my great boss, the duly elected district attorney, Mr. Lou Fazzulli of the great state of NIDA. Now, I am very sorry that you all have to be here, and that's because of the defendant, Dan Jones, and Cut Rate Liquors. We also refer to them around my office as third-rate liquors. Now, you're just going to find out today, members of the jury, that Dan Jones sold liquor, intoxicating liquor, to the town drunk, Walter Watkins, on June the 3rd of last year. Now, this is not Mr. Jones's first trip on the merry-go-round, members of the jury, and I'm sure his high-priced lawyer, Mr. Dan Tully, with his Rolex and his Mont Blanc pen, because they make a lot of money at Cut Rate Liquor selling booze to children and town drunks. And thank goodness they didn't give that man a set of car keys when they sold that drunk that alcohol on June the 3rd. Members of the jury, we might be here in a DUI manslaughter case. So thank goodness for that. But I can tell you at the end of this trial, you are going to know what I already know. And that is that that man is guilty, okay? You're going to hear from Inspector Beer. I've known him all my life. I can vouch for what he has to tell you, members of the jury. He's going to tell you there's no question Mr. Watkins was drunk. There's no question Mr. Jones knew that he was drunk. And that's the end of that story, members of the jury, no matter how much money they paid that guy.
Okay. Where do I start? Well, I'm a trial attorney. I've done a lot of cases. I know what I'm talking about, and I've just got some things that'll help you. Okay, first of all, your posture's terrible. I mean, you're slumping. You're not creating a good impression. You're a professional woman. It's embarrassing to me as a woman when you act that way. You're not telling us what you want anybody to do. You're attacking everybody. This is a high-paid lawyer. This is a terrible company. I mean, you're just giving all these negative attacks on everybody without any justification. Why are we talking about that? Why are we talking about crimes that didn't happen, like vehicular manslaughter? And why are we talking about the cop that you've known your whole life? I don't care about the cops. You've got to change all that. You've got to tell us what you want to do. You've got to stop rambling. You've got to stop, talking about how great it is to be here. You're sorry that they have to be here and all this stuff. I mean, you've got a lot of ums, a lot of ahs. I just got totally lost. So fix all that.
Well, I'm a trial lawyer too. I've tried about a couple hundred cases, and I think that was as good an opening statement as you will see any young assistant district attorney give anywhere in this country. You went right on the attack. You attacked the defense. If I could step down here and give you a hug, I would. It was that good. It really was that good. In my world, no objection, no foul, so a lot of those critiques, I don't really agree with, but you were forceful, you believed in your client, you let the jury understand that they should be afraid in this case, you focused on the financial motive, that this is a defendant who's willing to just do anything to earn money, and I just think it was tremendous.
Jennifer, I want to talk to you about avoiding argument, but before I get to that, I just have a slightly different view than Bob does. It seemed to me that in many jurisdictions you'd run the risk that you were shifting the burden over to the defense by saying what they would be proving and what you'd hear from them, and in many jurisdictions that'll be illegal, not something that you're able to do. But let me talk about avoiding argument, avoiding all the interpretation that you were doing. Stick to the facts. One test that you can use, and if you'll apply this, I think you'll get it down to the stuff that you need, is will a witness say it from the witness stand, or will a piece of evidence show it? If you put it through that test, you'll avoid the argument and you'll have a much cleaner opening.
Members of the jury, this is what we call an opening statement, and it's an opportunity for me to come and talk a little bit about my client and what they say happened. This isn't evidence. You'll hear some of that later. In fact, you'll hear some people testify like they said, and you may hear from Mr. Watkins. I haven't decided yet. But what we do know is that the prosecution's told you a story, and that's all it is. And They say my client sold a drunk man some liquor, and first of all, they got to prove that he was drunk. And I'll tell you, I have an Uncle Billy. Billy, he wears coveralls. He walks around kind of with a limp. He talks real slow, and it's hard to tell, whether he's drunk or not drunk, and he's not. He's got bad allergies. He goes into Walgreens, has to fill out papers just to get Sudafed nowadays, and you don't know, never know, and so it's hard to tell sometimes. But they've got to prove that he was drunk, and we don't think he can. And even if he was, he'd have to prove that there was a sale, and we don't know whether there was a sale or not, and so you got to keep that in mind. But what we do know is that mostly this is just a witch hunt. They heard all these calls and stuff to the police about selling liquor to minors, and then that's why they went out there, and that's what this is just a witch hunt, and don't let them buy it from you. Thank you.
Okay, where to start with you? Being younger and more attractive than my co-judge, I haven't done hundreds of cases, but I've done a lot, so I still know much more what I'm talking about. I mean, I really wish that you had listened to the critique that I'd given opposing counsel, because you could have fixed a lot of things. Talk about rambling. I didn't know what we were talking about. Uncles, cousins, cops. I didn't understand any of it. You're telling personal stories. You weren't really using any good facts. You're undercutting your own case. You're saying maybe he was drunk, maybe he wasn't drunk. We don't know. We don't know. We all know what we don't know. You need to tell us what we know. You're attacking everybody. You had so many verbal tics. It was ridiculous. You didn't have a theme. You didn't use notes, but you needed to use notes. You had your hands in your pockets. Again, you didn't look like a professional person. Why are you telling me what your job is and why we're here? I think we're all aware. And, Uncle Billy, and you kept just saying he. Which one? Which person are you talking about? So again, fix all that.
I guess even the broken clock is correct twice a day, right? So I agree with what was just said to you. My first question to you is, do you have really valuable stuff in your pocket, like gold coins or Matchbox cars or like your pet frog, because you're standing there, with your hands in your pocket, and you really need to fix that. You understand that? Okay. If you're gonna waste our time, then don't get up, okay? If you're gonna waste the jury's time, don't get up. You have a function here. Know what you're doing, understand what your goals are, or else don't even come, okay? Don't even come here. The Uncle Billy stuff, I don't really know where that's coming from. The only thing that matters in this case is what Walter Watkins did at the threshold of the store, and what happens from that point forward, and contrasting it from what happened before that point. So, really give some serious thought about what you're gonna do with your career. I know you've spent a lot of money in law school, but you really have to wake up.
Dan, in the middle of your opening, there's a gold nugget. You talked about whether Dan Jones knew that Walter Watkins was drunk. And that's the piece I think that you want to keep, and we'll bring that to life. Very often when you're starting this, you want to talk about everything. And you basically talked about all three defenses: no sale, was he drunk, and maybe Dan Jones didn't know he was drunk. So go for one of those, keep that, and then you'll get it nice and clean. And go right to that at the beginning, and you'll have a nice clean opening. We'll take care of the rest of that, but you'll have a better time the next time.
That's really nice, just not really helpful. You need to focus in on what I am telling you. I practice in the real world. I practice in the Southern District of New York, the Cathedral of Trial Courts. I know what's going on. This is a battle. You need concrete advice to get you going, if you're gonna do this. If you're not gonna do this, then you could just move on and listen to niceties.
Faculty, good afternoon. How are y'all doing?
Good. Hi, Zelda.
Good. Listen, it's the end of the day, and when I got back to my office after lunch, I got 2 emails from the students. You worked in the opening statement session with Jennifer and Dan. Do you? I mean, they were pretty upsetting emails. Do you know what's going on? Oh, okay, Bob. What happened?
It's kind of a bit of a joke in here today.
Okay.
Right?
That's news to me. Megan?
Oh, I thought it was great. A couple awkward moments, but I think we made a great team.
Okay, Jay, so what's going on from your perspective?
Well, I'm not sure what the students were concerned about. I was concerned. It seemed to me, Megan, I have to tell you, it seemed to me that you gave them an awful lot of information without a lot of clear guidance without sticking to 1 or 2 points, so I thought they looked like they were a bit overloaded. Bob and I seemed to express some disagreement. I tried to express my disagreement with him in a fairly professional way, but it seemed to me by the time we got to an end of it, he was pretty well picking a fight with me, and I'm not sure whether the students picked that up, but I suspect they did.
Well, I'll tell you what, Jay, they actually did. And so the students both said they didn't have any understanding of what to fix after their session, and they felt very confused. And so I just want to remind you all, because you all are part of the core faculty, that this is a student-focused program. And so your critiques have got to be student-focused. And I want you to stick to the teaching methodology. You all bring different great skills and information
you keep
to
looking
convey.
at me.
I'm not looking at you.
There's a right way, there's a wrong way of doing it. I'm in the real world, I'm practicing, I'm trying cases, heavy cases.
We know.
I'm giving constructive criticism. I'm not giving intellectual points like law professors give.
Right,
okay? And that's
right.
important to give to the students.
Well, Bob, what's important to give to the students is something they can hear. That's why we have a proven methodology that works. Remember, head note, playback, prescription, and rationale. You've got to be able to give them information in small bits so they can grab onto it. You can't give them a laundry list of things to fix because they're going to tune out. You've got to give them information from their actual presentation so that they can understand, hey, you were listening to me. You were focused on me. And so no war stories. When you're talking about the fix at the end, don't give them your war stories. Give them something that they can work their magic on. So I really want you to maintain what you do well, but make sure it's student focused, and the debate amongst you can't come up to the students, because then they feel like they're lost in the whole exercise. And I know you all don't want these emails. I know I don't want them. And you want the students to have a great experience, and I want you to come back.